I'm going to read to you all some preliminary pretrial instructions. Then we'll hear the opening statements. If there's anything I say you didn't hear me or couldn't hear me because I'm not speaking up or I'm mumbling, which I start to do from time to time, if you'll please tell me, I'll speak up and repeat it for you. Now, the witnesses will be testifying over here on my right and y'all's left, kind of between us here. You should be able to hear them also. If a witness said something you didn't hear or couldn't hear them because they weren't speaking up, you please tell me. I'll have them speak up or repeat it for you. Also, you all should be able to hear the lawyer's questions and comments. If you can't hear something because they weren't speaking up or you just didn't hear them, you please tell me. I'll have them speak up or repeat it for you. Also, you all should be able to see everything. If something happens and you can't see something because somebody's in the way or you just can't see something, you please tell me. We'll move us around or move you all around where you're able to see. It's important that you all see and hear everything. I don't think any of this will be a problem, but if you couldn't hear or see something, please tell me. We'll speak up or move you around where you're able to see. I don't think any of that will be a problem, but we will ask, of course, that y'all pay careful attention to the proceedings, of course, and if you can't hear or see something, please tell me. Y'all should have been given some notepads there on your chairs. If you run out of paper or your pen runs dry or your pencil, if you have one, gets too dull, please let us know. We'll get you some more pads. We got plenty of them over here. So if you run out of paper, just let me or Miss Yvonne or one of the officers know. We'll get you another pad if you run out of paper. If any of y'all need to use the restroom during the course of the proceedings, please let me or one of the officers know. Ordinarily, I acknowledge it's none of my business, but I don't want you over there uncomfortable. You got to go, you got to go. So I want you to let us know if you need to use the restroom or have to take a break, let you run into the restroom if you need to. Any smokers? Got any smokers? It's okay if you are. Okay, Mr. Kirby, it's okay if you are. Here's why I asked. One time a few years back, I had some jurors, every one of them was a smoker, and I forgot to ask them if they were smokers. Consequently, I forgot to let them go downstairs and smoke. After the trial was over, I got chastised by all of them. I deserved to be chastised because I forgot to ask. So I make a note. It's such a life-altering event, I make a note about it. So Mr. Kirby will let you go downstairs and smoke from time to time. If any of the rest of y'all intend to start smoking, we'll let you take breaks from time to time to go down and smoke also. So if that becomes an issue, please let me know. There may come times during the trial where I may have to briefly interrupt the proceedings and take up matters outside of y'all's presence. I don't anticipate too many eruptions, but they may come up. If they do, please bear with us. We'll keep them to a minimum. It's my obligation to make sure things move along here as smoothly as possible, and I'll do my best to do that. But if you get irritated, don't hold it against the state or defense. Get irritated at me because it's my job to make sure things move along here as smoothly as possible, and I'll do my best to do it. Now, Mr. Bowden, Ms. St. Lot, and Ms. Garcia, y'all have been selected as our alternate jurors. What that means is if during the course of the trial one of the other folks gets ill or some emergency arises or something happens that we're not anticipating, of course, and can't deliberate the verdict in this case, one of you all would step into that person's place if that becomes necessary. So we will ask, of course, that y'all pay careful attention to the proceedings in case you are needed to deliberate the verdict. It may not happen, but it might. At the close of the trial, after the final arguments have been given and the final instructions have been given, if the other 12 folks make it, you'll be released at that time, but we will ask that you pay careful attention to the proceedings in case you are needed. Now, I can illustrate y'all's role with a very, very poor metaphor. Any of y'all three want to hear it? Okay, at least one does. Y'all don't take this the wrong way. Y'all are kind of like the spare tire in the car. You kind of get to go along on a trip with us, but we may not need you. I told you it was a poor one. But spare tires are important, aren't they? Anybody ever had a flat tire? So spare tires are nice. There are 3 spare tires there in case we're needed. But we will ask that you pay careful attention to the proceedings in case you are needed to deliberate the verdict. Members of the jury, you all have been selected and sworn as a jury to try the case of the state of Florida versus Eriese Tisdale. This is a criminal case. Mr. Tisdale has been charged with first-degree murder of a law enforcement officer with a firearm, aggravated assault on a law enforcement officer with a firearm, possession of firearm or ammunition by a convicted felon, and fleeing or eluding a police officer. The definition of the elements of those crimes will be explained to you later. It is your solemn responsibility to determine if the state has proved its accusation beyond a reasonable doubt against Mr. Tisdale. Your verdict must be based solely on the evidence or lack of evidence in the law. The indictment is not evidence and is not to be considered by you as any proof of guilt. It is the judge's responsibility to decide which laws apply to this case and to explain those laws to you. It's your responsibility to decide what the facts of this case may be and apply the law to those facts. Thus, the province of the jury and the province of the court are well defined and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the attorneys will have the opportunity to make their final argument. Following the arguments by the attorneys, the court will instruct you on the law applicable to this case. After the instructions are given, our alternate jurors, Mr. Bowden, Ms. St. Alot, and Ms. Garcia, will be released, and you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all the evidence, the arguments of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case among yourselves. During the course of the trial, the court may take recesses during which you will be permitted to separate and go about your personal affairs. During these recesses, you will not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about this case. If anyone attempts to say anything to you or in your presence about this case, tell him that you're on the jury trying the case and ask him to stop. If he persists, leave him at once and immediately report the matter to the bailiff, who will advise me. The case must be tried by you only on the evidence presented during the trial in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. Accordingly, you must not visit any of the places described in the evidence, and you must not read nor listen to any reports about the case. Further, you must not discuss this case with any person, and you must not speak with the attorneys, the witnesses, or the defendant about any subject until your deliberations are finished. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it's made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. Mr. Tisdale, the defendant in this case, has been accused of the crime of first-degree murder of a law enforcement officer with a firearm, aggravated assault on a law enforcement officer with a firearm, possession of a firearm or ammunition by a convicted felon, and fleeing or eluding a police officer. The law applicable to those crimes will be given to you in the second part of the charge. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial unless it's been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is the evidence introduced in this trial and it alone that you're to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It's up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence, and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses act as well as what they say. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Does the witness seem to have an accurate memory? Is the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with other testimony and other evidence in the case? You may rely upon your own conclusion about the witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. These are some general rules that will apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the laws that is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you hear from the testimony of the witnesses, see in the form of the exhibits in evidence, and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding the verdict in this case is exclusively your job. I cannot participate in that decision in any way. Please disregard anything that I may say or do during the trial that may make you think I prefer one verdict over another. This concludes part one of the instructions. When all the evidence has been taken and the lawyers have made their closing arguments to you, the court will give you part two of the instructions. One other comment about the note-taking. You all may take notes during the trial if you wish. However, you're not required to do so. The choice is yours. Please bear in mind that during the trial, it is important that you not only listen carefully to the evidence, but that you also observe the witnesses and evidence. Thus, if you do take notes, please be sure you do not get so involved in note-taking that you become distracted from the proceedings. If you take notes, they may be used to refresh your own memory of the evidence during the trial and during your deliberations at the end of the trial. Also, if you take notes, please be sure to give them to the bailiff at the end of the trial. They'll be destroyed and no one else will read them. And again, if y'all run out of paper or pen, please let me or one of the officers know. We'll get you some more. You'll give Mr. Eisenhower your attention, please.
On February 28th in the morning of 2013, this defendant ambushed Sergeant Gary Morales, murdering him in cold blood as he sat in the driver's seat of his patrol car. The evidence in this case is going to show that Sergeant Morales never had a chance. This defendant had all the tactical advantage, and he took it and decided to kill Sergeant Morales. Gary Morales and his lieutenant talked about a day or so before about the Silver Lakes neighborhood where this happened, and talked about an increase in minor crimes, car burglaries, vandalism, minor thefts. And they thought it would be a good idea to get out in front of that by doing some proactive police work, proactive patrolling, you'll hear some of the deputies refer to it as. Showing a presence in the neighborhood, being there and stopping cars for traffic infractions. And you're going to hear from a lot of the deputies that are involved in this case that they were actually out at a traffic stop, at a routine traffic stop when this happened with another person in St. Lucie County in that Silver Lakes area. And what you're going to hear is that Sergeant Morales got his group together, his team of guys that he supervised, and they talked about that morning about this neighborhood, and that they were going to work this neighborhood and do exactly that, what we call proactive patrolling, stopping people for minor traffic infractions, figuring out who's in the neighborhood, who should be there, who doesn't live there, who doesn't have a reason to be driving through there. And if they see a traffic infraction that they might ordinarily let drive on by, make the stop. And that's what they were doing that day. And as I said, you're going to hear that all around this neighborhood there were deputies out with motorists at the time that this happened. The evidence is going to show, and we know that Sergeant Morales was on Canner, turning left onto Mura Drive when he turned his lights on to stop the defendant. They both were on Canner, turning left onto Mura, going south, and you'll hear the radio transmissions from Sergeant Morales. And again, you're going to hear a professional law enforcement officer calling in what he believed to be a routine traffic stop. You're going to hear that he calls out that the stop has taken place in the 3200 block of Mura. And then at the intersection of King Orange and Mura, and you're going to hear that Sergeant Morales followed the defendant this entire block, about a car length behind or less, with his lights activated, trying to pull him over. Incidentally, speaking about trying to protect the people in this neighborhood from these minor crimes, the defendant lives in this neighborhood right here on the corner. So the deputy, Sergeant Morales, followed the defendant. The defendant turned right. We know that he turned right onto King Orange. We know that Sergeant Morales turned the corner and stopped right at the corner on King Orange for about 3 to 10 seconds. Not long enough to get out of the car, and he didn't get out of the car, long enough to just be stopped. From there, we know that the defendant fled. We know that Sergeant Morales, and you'll hear the evidence of this, as Sergeant Morales calls it out on his radio, that he's running, that he is fleeing in his car. And so Sergeant Morales follows him, and we know that the defendant was gaining speed and turned quickly north on Naylor. And the evidence will be that Sergeant Morales followed him and called it out north on Naylor. You'll hear from a number of the other deputies that worked under Sergeant Morales, and they started, some of them wrapping up the traffic stops they were on, some of them just finished traffic stops, and a few of them started coming to this area as a backup to Sergeant Morales. The evidence is going to be that the defendant, about 3/4 of the way up the block, slammed on his brakes. And this is a dirt road, and Sergeant Morales had to avoid him to the left. His car slid in the dirt and ended up in front of the defendant's car. He came out in front of it, he got turned a little bit and slid in front of the defendant's car. The defendant got out of his car and took his gun, his fully loaded .45, and started after Sergeant Morales. And there was nothing Gary Morales could do. The defendant fired a shot right as he was right out the door, and you'll see the evidence that shot hit the back of Sergeant Morales' car right where the gas tank is. And then he pressed his tactical advantage. He had Sergeant Morales in the car while the defendant's getting out and shooting. Sergeant Morales, you'll hear, was having a heck of a time trying to get out. He's pushing the door open. He's struggling either with his seatbelt or trying to get his gun, trying to get the car in park or in gear. He's clearly having a heck of a time trying to get out. And as he's doing that, the defendant is running towards his open door, because as I said, Sergeant Morales kicked the door open. He's running towards his open door and advancing with each shot, and fired multiple shots into Sergeant Morales. He shot Gary Morales in the head, in the neck, in the chest, which his bulletproof vest stopped, and in the arm. We know the defendant fired his gun 7 times out there. We have 7 shell casings. Fired his gun, the gun he chose to take out there with him when he decided to kill Sergeant Morales. And as I told you, there were deputies coming at the time. And as the deputies were coming around, Clarence Bennett is on King Orange and just kind of catches a glimpse, almost just the dust of Sergeant Morales going around the corner chasing up Naylor, the defendant. Clarence Bennett, deputy, as he's turning the corner, hears the first of the shots, or hears shots. As he gets about halfway up the block, he stops. He can now see, again, there's a lot of dust, it's a dirt road. He can now see the defendant standing in the doorway shooting his sergeant. Deputy Bennett gets out of his car. He doesn't want to be trapped in that car. He gets out of his car and he starts shooting at the defendant. The defendant turns from where he shot Sergeant Morales and he points his gun towards Deputy Bennett. And what you'll hear is that the defendant, as he was shooting into the car, turns and keeps his arm straight and runs back towards his car, pointing his gun up the road at Deputy Bennett. Deputy Bennett, again, is trying to shoot the defendant. He doesn't know whether a shot was fired at him or not, but he knows the gun was pointed at him, and he fired at the defendant multiple times. And you'll see that there's a bullet strike in the defendant's car from Bennett shooting at him. The defendant got back in his car, got around. There was room enough for him to go around Sergeant Morales' car and drove north on Naylor to Cannon and made a right. Deputy Bennett is calling out that there's shots fired, and these deputies that were all coming from all around the neighborhood here already knew the description of the car because Sergeant Morales had called it out. Red Corolla. The defendant, moving very quickly, drives east on Canner, and at that time Nate Stubley, who's the deputy, is coming up 7th Street. The defendant, right as Deputy Bennett's calling out shots fired, the red car pulls out in front of Nate Stubley, and he had another deputy with him in his car with him, Briglia. So Deputy Stubley and Deputy Briglia chase the defendant north on 7th. The defendant turns right on Glenview. As you can see, Glenview intersects with US 1. The problem is it's about 9:30 in the morning, and US 1 is jam-packed. So the defendant gets down here to the end of the road and begins to slow down and look like he's going to make some kind of maneuver. Deputy Stubley gets out of it, stops his car, puts it in park, gets out because he believes that the defendant is either going to run on foot or turn back towards him, and again, he doesn't want to be trapped in his car. He gets out, he draws down. The defendant makes a U-turn here into US 1 and then back up Glenview. Deputy Stubley doesn't shoot the defendant. The defendant goes past him and heads now west on Glenview. As he gets to the end of this street, another deputy, again, because they're all right in the neighborhood making traffic stops, another deputy, Sarvis, is waiting there at the corner. Stubley got a good look at the defendant as he was driving towards him, and certainly the defendant got a good look at him. The defendant got to the end of the street, and Sarvis looked him in his face, and the defendant was laughing as he turned right onto 7th. As you can see from this, you can't get very far on 7th before a U-turns around and you have to come back south on Dubin. So the defendant did that with now multiple deputies chasing him, all lights and sirens activated, as you'll hear the elements of the crime, fleeing and eluding. And they chased him down Dubin to Canner, where he turned right, literally returning to the scene of the crime, which happened right here. Like I said, about 3/4 of the way up Naylor. The defendant then cut through this field in his car, drove behind the back of this church that is on Oleander and Canner, and down Lake. Deputy Sarvis, who picked him up here, who the one that saw him laughing, was behind him the whole way, and eventually was able to get close enough as the defendant slowed down, because he was going to have to make a turn. As he slowed down to make the turn here at Lake and King Orange, Sarvis was able to ram him. Sarvis rammed him in the back of his bumper using his patrol car. He rammed him at Lake and King Orange. He rammed him again on King Orange right at Oleander, and again on Oleander, and eventually was able to do what's called the pit maneuver. Now, what that does is that causes the defendant to spin out. He pushes the defendant's car in such a way that it causes him to lose control of the car. The defendant was in a crash, and then his car ended up on the side of the road down on Oleander in the grass. The defendant got out, put his hands up, and got face down on the grass. In fact, you'll see the picture of him. He's still got some of that grass on his chest. I guess it had just been mowed, and he's still got some green grass on his chest from that area where he got down on his face, on his chest. And that's where the defendant was taken into custody. Now, as Mr. Backetall told you, whatever it was, several days ago now, we don't have to prove motive. But he had one. The defendant knew when Sergeant Morales started to pull him over that he had a suspended license. The defendant knew that when Sergeant Morales stopped him and ran his records, he'd find out about the suspended license and he'd arrest him. And he knew that when he got arrested that his car would be searched. And he knew that when his car was searched, they were going to find his fully loaded .45. And he knew that he was a convicted felon and that Sergeant Morales would know it when he ran him. So he knew that he was going to jail for possession of a firearm by a convicted felon and for driving on a suspended license. And he wasn't going to just spend a few days in jail for driving on a suspended license. He was going to prison for possession of a firearm by a convicted felon. What he didn't know is that when he murdered Gary Morales, there'd be 6 other deputies within 2 blocks. And he wasn't going to get away with it. What he did know was that if he killed Deputy Morales, he had a chance of not going to prison. If he stopped and let himself get pulled over, he was getting locked up. At the end of this case, we're going to ask you to find the defendant guilty of all the crimes he's charged of. Because he's guilty of possession of a firearm by a convicted felon. The evidence is going to show that he was a convicted felon and that clearly he possessed a firearm. The evidence is going to show that he led the officers on a chase around this neighborhood when they had their lights on and their sirens activated, and he's guilty of fleeing and eluding. The evidence is going to show that he pointed his gun at Deputy Bennett in a way that was threatening, and that Deputy Bennett had a well-founded fear that the defendant was going to shoot him just as he'd witnessed him shoot his sergeant. We're going to ask you to find him guilty of that. We're going to ask you to find him guilty of premeditated first-degree murder of a law enforcement officer, because that's what he did. Because he decided that he would get his gun, get out of his car, and kill Sergeant Morales when Sergeant Morales had no chance. You're going to hear that Sergeant Morales' gun was still in his holster when he was killed. That he was sitting in his police car. That he had a foot out of the door. That he was shot in the head, in the neck, and in the chest, and in the shoulder by this defendant. That he never had a chance. We ask you to find the defendant guilty of the crimes charged. Thank you.
Mr. President, if I can get you to take the...
Oh, sure.
Yes, if you may, could you have me read that?
Oh, sure, I'm sorry. Beg your pardon. If you'll give Mr. Glenn your attention, please.
Good afternoon. Sounds pretty bad, doesn't it? It is bad. As I said to you several times, a man died. Another man's life hangs in the balance. This will be very instrumental throughout the trial. Not so much what happened after the shooting, but before. Take a walk with me through this. This is the case about a sudden and spontaneous act. State and defense disagree on something, but one thing we do disagree on is this. Mr. Tisdale turned onto Muir Drive. Sergeant Morales turned onto Muir Drive. Why is that important? Because Mr. Tisdale lived at 3247 Muir Drive, at the corner of King Orange and Muir. Think about that for a minute. February 28, 2013, by all accounts, it's a normal sunny day. Bright, cool, great Florida weather. Mr. Tisdale is driving his red Toyota Corolla down the street. He's almost home. As he's driving, he sees the police officer. Police officer then turned on his lights and started to follow him. By all accounts, this was a normal day. Mr. Tisdale thinks, okay, there's an important fact. Sergeant Morales turned on his lights. He did not turn on his siren. Mr. Tisdale is no stranger to law enforcement. Law enforcement officer gets behind you. You automatically think it's normal when lights and sirens go on. That didn't happen this time. Lights went on, but no siren. And a chase started down Muir Drive. Now, why didn't Mr. Tisdale stop? We don't know. But we do know he lived at the corner of Muir and King Orange. And you're going to hear evidence that Mr. Tisdale went down to where he lives. You're going to hear evidence that Sergeant Morales followed him to that area. You're going to hear evidence that Sergeant Morales' car stopped. It's in dispute whether or not Sergeant Morales had enough time to get out of the car. I have to admit to you that he did. They say he didn't. You will be the one to decide. Now think about this. Sergeant Morales' car stops right in the area that Mr. Tisdale lives. The government has charged Mr. Tisdale with first-degree premeditated murder. Fleeing, eluding, aggravated assault, forget all that. Sergeant Morales' car stopped right where Mr. Tisdale lives. And then proceed on. Also, these are dirt roads at the time. Very important fact, don't forget that. This indicates about a sudden and spontaneous act. What happens after starting the morale, the car stops? Well, we know shortly thereafter, it started moving again. We know a radio call was made. Well, how is that important? There was enough time to make a radio call. And then the car started moving again, right at the area where Mr. Tisdale lives. Now it starts to speed up. Mr. Tisdale driving down King Orange and makes an abrupt right onto Narrow Terrace. Remember, it starts here, Cannon Muir. Mr. Tisdale's house, King Orange. What happened here? Honestly, we don't know. They don't know, I don't know, nobody knows. But we do know Sergeant Morales called it out. And you're going to hear that. And you're going to hear from a lady who tells you that she thought Sergeant Morales' car stopped. Because she's this way. Mr. Tisdale lives here. The chase goes down King Orange, high speed. Why is it high speed? Make the right on Nail. We're coming up Nail now. At the area I just showed you, there was an open lot. And it's part of a house that faces Muir Drive. This indicates about a sudden and spontaneous act. Sergeant Morales is right on the heels of this red Toyota. Something happened. Mr. Tisdale slammed on the brakes. But wait a minute. Before he does that, he noticed there's something else that's unusual. You know, we've got this law enforcement officer chasing him in a marked patrol vehicle with the lights on and no siren. Right around the corner from his house. But something else happened. Sergeant Morales goes to the left of Mr. Tisdale. Comes up on the left side. Now they're like this. Is that normal? Mr. Tisdale slammed on the brakes as soon as that happened. Sergeant Morales slammed on the brakes. Little red Toyota stopped faster. Sergeant Morales' car is bigger and heavier. Law enforcement officers drive bigger cars. It slides. And it slides over in front of Mr. Tisdale. Break this down. What is wrong with what's going on here? It's not normal. It's not correct. Mr. Tisdale is no stranger to law enforcement. So that's good and bad. But what's relevant about it is the fact that he has had experiences with law enforcement where traffic stops are done a certain way. This one was very different. Both cars come to a stop. There happened to be two gentlemen working in that open field. They're mowing the yard, they're cleaning it up, they're right there. Red Toyota comes to a stop, police car comes to a stop. Mr. Tisdale throws open the door of his car, Sergeant Morales kicks open the door of his car. Mr. Tisdale comes out of his car with the gun. Runs over, he fires. He fires again, and again, and again, as if you don't autopilot, he keeps firing. He does hit Sergeant Morales, I believe 3 or 4 times. Now, because of that radio call, Deputy Bennett, coming down here, right behind Morales. Deputy Bennett takes the same route. Deputy Bennett gets here. He hears shots being fired. Or what do you think the shots being fired? He turns the corner, comes up there. He sees shots being fired. he stops, gets out of his car, draws the weapon, and starts firing at Mr. Tisdale. Mr. Tisdale then sees this, turns around, and has his arm stretched out. And he starts running back to his red Toyota. Now, Deputy Bennett can tell you that he believed Mr. Tisdale was intentionally pointing at him with a gun, trying to shoot at him. Two men in the yard are going to tell you they saw this thing from start to finish. They saw Mr. Tisdale while he was driving, when he stopped, when he got out of the car, when he went over and fired the shot, and then they're going to tell you when she stopped firing, he ran with his arm outstretched back to his red Toyota. That they never saw him point and aim at Deputy Bennett. Very important fact. You know, all that talk we had about conflict and eyewitness testimony? Here it is. You will decide what are the facts. But Mr. Tisdale is being shot at closely. Deputy Bennett doesn't hit him, but he comes close. Mr. Tisdale makes the back of his car, gets in the car, and takes off. I'm not going to get into too much detail about the route that was traveled, but I will tell you this. If you think about the path that was taken, where you are, where Mr. Tisdale lives, I submit to you that will give you a lot of clues about what's going on here. I can't make argument to you, so I'm not going to, but I want you to think about this. Try to think about why things happen the way they happen. Think about how people can react based on what's going on in their surroundings. We've talked about this for days. Here it is in real time. So, Mr. Tisdale takes off. He's being chased all over the Silver Lakes neighborhood. And then eventually he stopped because a law enforcement officer, Deputy Sarvis, disabled or make it so that his car loses control. Very important. Did you notice what Mr. Eisenhower said? Mr. Tisdale gets out of the car, puts up his hand, and gets down on the ground. And he also says, "Don't kill me." It indicates about a sudden and spontaneous act. Bad fact, I know. But I would submit to you that when you get done listening to all the evidence, not just what people tell you, but remember we talked about this, how it fits together. And then looking at why would someone do the things they do, and how could someone else react based on their personal circumstances. And when you do that, I would submit to you, you cannot find Mr. Tisdale guilty of premeditated murder.